Good morning. I think Mr. Hill, we have video and audio from you. We're still, we just got it.
Good morning, Your Honor.
Good morning. Welcome to probate court number 2 virtually in Tarrant County, Texas. I'm actually in the courtroom, so if anybody needed to be heard on this matter, they would be. This is the estate of Troy Jean McCarty. This is the ancillary matter with our dependent administrator, Mr. Hill, who's also an attorney. And he is also as guardian of the estate versus JP Morgan Chase Bank. And this is the request for JP Morgan Bank to interplead funds into the registry. And then right after that, we'll have the application to set aside the homestead. I will remind y'all, we are live streaming on YouTube today. If you're joining us on YouTube, welcome. I'll just remind you that you are not allowed to record this matter, that the court has the original and only official copy. So counsel, if y'all will just announce yourself for those watching us.
Good morning, Your Honor. Aaron Gottlieb for JP Morgan Chase Bank, the defendant and counter plaintiff in the ancillary matter.
Good morning, Your Honor. This is Brian Hill. I am the guardian of the estate for Arcelia McCarty, the dependent administrator for Troy McCarty, and the plaintiff in the ancillary action.
Okay. All right, Mr. Gottlieb, you may go ahead. I have read y'all's counterclaim for Interpleader and the attachments.
Thank you, Your Honor. The Interpleader seeks a determination of, the ancillary matter essentially seeks a determination of the interest of certain monies held in a Chase account ending in 7110. Originally on January 16th, the plaintiff filed this original petition for a declaratory judgment against JP Morgan Chase and to seek turnover of assets, specifically the monies held in the 7110 account. According to the petition on April 11th in 2019, this court entered an agreed order in the guardianship matter, adjudging that 2 Chase accounts, one ending in 4895 and one ending in 5548, were community property, and requiring Troy McCarty at that time to deliver 1/2 of the balance of each of the accounts to the court. The petition goes on to allege that Troy McCarty, who is now deceased, opened a Chase account ending in 7110 using community funds held in the Chase account ending in 5548, which was one of the accounts which this court required Mr. McCarty to turn over as a part of the April 11th, 2019 order. Upon the death of Troy McCarty and the appointment of the plaintiff as the dependent administrator of the Troy McCarty estate, plaintiff sought leave to file this ancillary action. Essentially, this action seeks a determination as to whether the amounts of the monies in the 7110 account arise out of community funds and what percentage is owed to Miss McCarty and the estate of Mr. McCarty. Mr. Hill will will let you know if I'm mischaracterizing that, but I believe that's the case. We filed a general denial on February 18th of 2020, and we filed this interpleader action simply as an opportunity to tender the funds to the court so that Mr. McCarty, Daryl McCarty, and the estate of McCarty and the administration and Mrs. McCarty can fight over who is the lawful owner of the funds. The total amount in the account at the time of the petition was $33,422.93. That account has been frozen. That's according to a February 25th, 2020 statement. The McCarty guardianship, the McCarty estate, and Daryl McCarty appear to be adverse claimants on these funds. To give you a little bit more specific information, the funds in question in the account, there's a payable on death to Mr. McCarty. That's Daryl McCarty. He is the son of Troy McCarty. That's where the discrepancy comes as to whether or not those funds in that account, the state has a claim to those funds, which Mr. Hill has begun discovery in order to determine. And because the McCarty guardianship and the McCarty estate and Daryl McCarty appear to be adverse claimants, we're claiming that they're entitled to the monies held in the Chase account, then Chase is essentially a innocent bystander in this, in terms of we have no stake in the money. because we have no stake in the money, we think it would be appropriate to interplead those funds. And because we did not cause any of the because we didn't cause any of the adverse claims, we also think we're entitled to reasonable attorney's fees dealing with solely with the interpleader. The interpleader, the amount that we requested as our $2,400 plus costs, we uploaded an order which reflects those costs, which were minimal. Those include the filing fee of the interpleader and service on Daryl McCarty. And so we would request that the court enter the proposed order. We did leave a blank on that order so we know who to make out the funds to, because we would like to put these into the registry of the court and essentially dismiss Chase from the action. I've spoken to Mr. Hill on 90% of this. We've done some discovery in the case, provided him information on this case. And Mr. Hill, and of course he'll tell you if I'm misrepresenting his stance, is in agreement in terms of the request that the relief that we're requesting in the interpleader, as well as does not oppose the attorney fees or costs relating thereto.
Okay, Mr. Hill.
Judge, we're not opposed to the interpleader. We have sent out discovery. I have all the documents that I believe that we need from Chase. Mr. Daryl McCarty has sent a response to me, which is on file with the court.
I was just looking at that, so thank you for filing that.
As a housekeeping matter, he has not officially been served in this matter by me. He has been served by Chase.
Okay.
And I'm going to be sending a request for substituted service into the court because they're not accepting any visitors at the facility where he's residing. So we're going to be requesting certified mail. Even though the answer's on file, I want to make sure that the proper service has been made.
Okay.
As I said, we're not opposed to Chase tendering the funds into the registry of the court. And we're not opposed to his attorney's fees as well.
Okay. I did have a question. This last paragraph of your order is extremely broad, and I'm not sure I completely understand it. Saying that essentially Chase is, well, actually the plaintiff and the counterclaim defendant are permanently enjoined from filing suit or otherwise seeking recovery against Chase with respect to its actions relating to the Chase account. And it does not specify which account, so I'm going to specify which account.
Okay.
7110. And then it says prior to the date of the order. I think that's a little broad. I think that this case is about just 7110. And I'm not saying there's anything out there that Chase has done that they could be liable for, but I also don't want to prejudice anyone's rights. So I have interlineated that you are going to send it to the address attention to the Tarrant County Clerk, Mary Louise Nicholson. And then I've ordered that the funds shall be held in this case and invested until further order of the court, which is typical for the clerk to do. And then I have specified at the end that they're enjoined from filing suit as to this account ending in 7110. And since there's no objections to the attorney's fees, I'll grant those as well. I assume, Mr. Gottlieb, once you put those into the registry of the court, y'all are going to be asking for dismissal?
Yes, Your Honor. If the order does not request does the order request a dismissal itself?
Well, it says you're hereby discharged and dismissed, but I am going to put after you interplead the funds.
Okay. We'll file a request for dismissal at that point.
Okay. And I guess your last paragraph goes to you're dismissed with prejudice, so they can't sue you again. But okay. I'm going to sign the order, and Ms. Clay will send that both to you. Mr. Gottlieb, you're welcome to stay with us for the next hearing, or you are also welcome to leave since you are no longer a part of this.
We will let Mr. Hill take over here for us, but we appreciate you allowing us to appear via Zoom, and apologize that the grooming is not up to standard. It's not quite ready to go to a salon, but I appreciate court's attention and ease when dealing with this matter.
All right, thank you. Have a good day.
You too.
Okay, Mr. Hill, we are a little early. We're supposed to start at 10:30, but do you believe anybody is going to be joining us? And this is on the underlying matter, the estate of Troy Jean McCarty, deceased. And
I do not.
okay, and it's an application to set aside homestead from general creditors of the estate. An order, or you've requested an application for allowance in lieu of exempt property, and an application to set aside family allowance. Is Daryl McCarty, has he made an appearance or done anything in this underlying estate?
He has not. So as you may recall, he was the named executor in the will. So we had served him and he did not respond. I have sent him a copy because this hearing may affect the other case. So I've sent him a copy of the application by mail, sent that about a month ago. There's a notice of hearing for the original application, which was supposed to be set, I think it was right when COVID hit. So it was in March. And he hasn't filed anything. So I went ahead and sent him another notice of hearing on Friday saying, hey, Daryl, this may affect the other case. And I haven't received any response. And it was virtually the exact same notice of hearing I sent him previously. So.
Well, thank you for trying to keep him informed. I know where he is located, and while it is a little harder to appear for a hearing, we certainly have done that many times from facilities like that as well. And we just send an order and they go to the library and either get on the phone or in this case, get on Zoom and they appear, and so it certainly can be done. So I appreciate you keeping him in the loop, even though technically you don't have to because he hasn't filed anything in this case and has been notified about it. Okay, well, you may proceed with your application.
Judge, before we begin, or at the beginning, I'd like to give you an update on the estate, just so you have the numbers.
Okay.
There's currently, as of this morning, in Troy McCarty's estate account, there's $49,871.59. $48,261.46 is from the sale of their property, their homestead, and $1,643.39 is the share of the personal property, which was sold at the estate sale. There's been a few debits since then, being for the bond. There's been a bank charge, and there's been a little bit of interest paid. So other than that, there's nothing else in that account. As far as his estate goes, there's a piece of property, which is separate property of Troy McCarty. It's valued at approximately, it's a undivided 1/2 interest in 2 lots. We're going to be putting that under contract for a total of $1,000, $500 of which will be in his estate because it's a 1/2 interest.
What neighborhood and city are those located in?
It's in Newcastle, Texas, which is near Graham. So it's on the tax rolls, I believe, for about $800.
How big are those lots?
I'm not sure.
Okay.
So I've come to an agreement with the co-owner, which is Troy's nephew.
Okay.
Sell those to the guy that has been leasing them for 18 years.
How much is the lease?
I think it's like $100 a year.
Okay.
It's not worth much. The taxes alone, I think, are like $50 a year, $50.
Leasing them for cattle or storage or?
I'm not sure what he's leased them for. I don't know, but I'm going to get all that information when we submit the report of sale.
Okay.
Other than that, there's nothing else left in Troy's. There's nothing else in Troy's estate.
Okay.
So we have requested to set aside the homestead, and in our application, that would include the proceeds from the homestead for the surviving spouse, Miss McCarty. So that would include that amount of $48,261.46 from general creditors of the estate.
Okay.
And according to the case law, as I stated, the proceeds, if the property's sold, the proceeds get set aside as well, according to the case law. So we're requesting that the court set aside that. Additionally, we're requesting that the court set an allowance in lieu of exempt property. As a background, Miss McCarty's guardianship allowance is set at $6,000 a month. I have submitted the annual accounting recently to the court. The distributions for last year, the total disbursements was $127,588.64, but a lot of that was per court order splitting the assets between Miss McCarty and Mr. McCarty.
Okay.
So of that amount, let's see, $61,725.80 was distributed to Mr. McCarty. So her room and board is $4,500 a month. So at minimum, I believe that the family allowance should be set at minimum 4,500 times 12.
Okay, which is what, 54,000?
About 54,000.
Okay. And then you understand that 54,000, only half of that would come out of Troy McCarty's estate.
Well, isn't it based on Judge? Isn't it based on his separate property? And he doesn't have much in separate property. But
well, what I'm saying is, if the community, typically when he was alive and the community spent $54,000,
right,
half of that was hers that she spent, half of that was his. So he's only responsible for half of that. So
correct. But I'm requesting that it be set at least 4,500 times 12, somewhere between that and the monthly allowance, which is 72 for the year.
Okay, how much was spent on Miss McCarty and her, I guess, paying the facility and those types of things?
So her room and board, according to the county, for last year, just the room and board alone, was $43,350.
Okay.
Her pharmacy bills were another $118.
Okay.
Her medical bills, we only had $205. But we did have a claim of $12,000 for previous room and board.
Well, but that's not within the year.
I understand.
Okay.
I understand. But I guess what I'm saying is at minimum, it should be $43,350. And I assume that's divided by 2.
Right, it would be divided by 2, but with the other items you've talked to me, we're at 43,673. So
correct.
Okay.
As
You
far
should
as
advertise this as a math show for all the learning online children, and probably, I don't know, 3rd, 4th grade.
I understand, that's why I put all 3 of my applications together and laid them all out there.
Okay.
The best we could. And
Okay.
Judge, we're also asking for an allowance in lieu of exempt property.
Okay.
She didn't have according to the Texas Property Code, it allows an allowance in lieu of exempt property, and any of the items that she did not have at the time of her death, according to the property code, we get an allowance for.
Okay.
She didn't have any farming or ranching vehicles, equipment or apparatus, jewelry. She didn't own any vehicles at the time of her death or any of those animals. The allowance can be up to $30,000. And in this case, I'm requesting the allowance be set at $5,000. And Judge, even though we are not hearing the ancillary case today, this order will have significant implications for that amount, because there's nothing else in the estate to pay the allowance from.
Okay. Anything else?
Judge, I don't have anything else in this matter at this time.
Okay. I am going to grant your applications. I'm looking at your order, page 1, number 3. It says a fair and reasonable allowance should be paid to support a decedent's surviving spouse. And that says $72,000, but didn't we just figure that out? It's actually somewhere around the 43,000 divided by 2.
Well, the number 72 came from her monthly allowance times 12. But we can set it in any amount. I would ask that the court set it at least, 12 months times the room and board, which is 4,500, and then I guess divided by 2.
Okay, that was the 26. 836, 50. And then we have paragraph 4 on page 2. So essentially number 3 is your family allowance.
Correct.
And then number 4, the allowance in lieu of exempt property, is the $5,000.
That's what we're requesting, Judge.
Just repeated those in the order. Okay, you've made the findings and then repeated them in the orders. Got it. Okay, those are granted. I have granted you the 26,836.50 as the family allowance, and the $5,000 as the allowance in lieu of exempt property.
Okay.
Anything else for today?
Judge, the only other issue was the issue of the substituted service. Did you want that to be by certified mail?
Well, have you already filed an application for that?
I have it drafted. It hasn't been filed.
Okay, well, I can't rule on it unless it's
Okay.
filed, either set for hearing or, as you know, we hear a lot of things on submission after 10 days of
Correct.
rejection.
All right. And just so you're aware, everything's been filed for the annual account on Miss McCarty.
Okay. All right. Well, thank you very much.
All right. Thank you.
Have a great week.
You too.
Bye-bye.